Back to the program. We got Mr. Joe Churchwell on the show. Joe is an attorney. And, Joe, how you doing this morning? I know it's early.
Yeah, I'm doing fine, Paul. Good to talk to you.
All right, good. All right, so let's go over this sovereign immunity situation. I mean, the Arkansas Supreme Court essentially now saying that the state of Arkansas cannot be sued. The king can do no wrong. What was your reaction when you found that out?
Well, I hate to say it this way. We have been working on that issue for months and had a feeling, in the pit of my stomach that the fix was in. In other words, that it was going to happen. And, I mean, the doctrine itself gives you a sense of the gravity of the situation. The king can do no wrong. In Arkansas, the executive, which is Asa Hutchinson, has numerous state agencies. Well, those are the king's men. You have the king, the king's men, which are the sheriffs, the magistrates. Nobody can be brought to task for any grievance if they are within or part of a state agency now in the state of Arkansas. And what that means are the state courts, circuit court judges. I also think that the implication goes all the way to the Supreme Court. In other words, that our Supreme Court cannot review now. And the power of review is nearly as important as, the power to rule or to make orders and judgments. One of the extreme remedies that we have in the state are writs of mandamus, writs of habeas corpus. Those are writs that are essentially a review by the most powerful court in the state. And I think this ruling prohibits writs against state agencies and state actors. Because if you don't have jurisdiction, you don't have jurisdiction. And what this is a subject matter jurisdictional issue, and that's a threshold matter. In other words, if you don't have subject matter jurisdiction, you have no power, you have no authority. And the Arkansas Supreme Court is a state court. So if I have trouble now with, say, a state agency, state police, for example, if I choose an extreme remedy in an extreme situation, such as a writ of habeas corpus or a writ of mandamus or a writ of prohibition, I don't believe the Supreme Court has the power to act now, not our Arkansas Supreme Court. And I think they may have painted themselves in a corner.
Wow. This is, that's a lot. This is actually a whole new layer to this that I haven't heard yet.
There are going to be layers, Paul, as we unpeel this onion. I don't think they realize the implications. I mean, it sounds great, and it's really good right now today for the Attorney General's office because all of their state litigation has gone away, pretty much.
Right. Yeah, that's exactly right.
You talked to Luther Suter the other day.
Mm-hmm.
Luther has been defending citizens for 22 years in this state, and a good portion of that, now thousands and thousands of cases you saw. Federally, in some instances, we're okay still, but there's sovereign immunity there, too, the 11th Amendment. There are only certain things that you can sue states for in federal court. Now, you cannot sue anyone in state court for anything, and a big part of Luther's business, Lucian Gillum, Luther Suter, before that, Mr. Harrell, they sued many times under this statutorily created waiver. In other words, the legislature
said you can sue the state if they do X kind of thing.
Exactly. And within that statute is that enumerated right. FOIA, for instance. Say I want to get something from Dennis Milligan by Freedom of Information Act. Okay, probably he's not going to give it to you anyway. He's going to say, even back before this happened, are we on terrestrial radio?
Oh yeah, we're on terrestrial radio. We're on across Little Rock, Jonesboro, Stuttgart, Fort.
Okay,
yeah,
then
yeah.
I'll clean it. I'll make sure I keep it clean then.
Yeah. Oh, good grief. Yes, please do.
Okay, I'm just making sure. Sometimes on cable they let us go with it. And I have a tendency to do that in situations like this. These are very emotional times when you've got clients that have been wronged, and for years Luther has cases that have been dragging on for years under Whistleblowers Act, Minimum Wage Act, Fair Labor Standards Act, Arkansas Civil Rights Act. These people were wronged by their government. Now, litigation is traumatic. Okay, that's really the word used. When you're in litigation, you're going to be traumatized, especially if you're going up against big pharma, big business, these corporations, and the government is the worst of all, because the person that's going to decide the case in state court is part of the government.
The government, yeah.
The man. So I think Luther had to dismiss or is going to more than 31 cases, I think was last count.
Really? So he had 31 cases, and they're just gone now because of this ruling.
Well, that's a cursory popping through what was there, you know. Yeah, because if you're suing under the Minimum Wage Act, that's gone. That was the case the Supreme Court chose to make their decision on. They took a little case out of Mina, and you know, Souter's firm had 3 cases. One against Arkansas Community Correction, where they, you know, inadequate health care for women, babies dying, and things like that. You would think that they would care about that. And obviously, they don't. They care about not being held liable for it. But there were several cases that were up to be decided on the sovereign immunity issue, and they decided this one first. So all of those acts that create a statutory right for the citizen in state court, and I'll break it back to the Freedom of Information Act again because it's really, really simple to understand even for me, is that if I issue a FOIA and they say we don't have the documents, or you're not entitled to the documents, or we are not subject to the Freedom of Information Act, you have one remedy, okay? You file suit. So where do you file suit? You file suit in state court. That remedy is gone.
Okay. So
being the only, because the state shall never be made a defendant in the court.
So do you have an avenue in the federal level then?
No, not for an Arkansas state FOIA. No, certainly not. Right now.
So what do we do? I mean, come on, let's talk about this. We can't sue. We can't make them enforce the Freedom of Information Act, which they don't like anyway, right?
And so constantly we're having to file suit, you know, over little stuff.
Yeah, yeah.
So the boldness of my next reply, next time I FOIA, I can imagine that it's not going to be able to be said on air what they tell me, because you should hear what they tell us before the act was found unconstitutional. But you know, what do? Time will tell. I think, and people think I'm cynical, and people think I'm a little bit crazy, but you know, the trauma builds up over years of dealing with these people, and not only the trauma that they put on you through the litigation process, but the trauma that you witness happening to your client. You know, and when I came on, you said it's Joe Churchwell. He's an attorney, right?
Yes.
Really, I'm not. Okay, I'm a lawyer, and at 5 o'clock, you know, I don't turn my computer off and go home, you know, and go play squash or whatever it is they do. You know, at 5 o'clock, I'm still at the office. If I get home, you know, I'm still working on my cases. My clients are still calling me, you know, literally trying to deal with the trauma of getting through this litigation, the time, the expense, the emotion. And to be going through that for years and years on these cases, some of the cases weren't that old. You know, some of the cases, Luther had 4 or 5 years in these cases. You know, they've already been dismissed. There's been a motion for summary judgment. They had to go to the Supreme Court. They've been remanded. You're finally getting to a trial, and then this happens. You know, and what do you tell them when they look at it? You know, how can this happen?
So just to kind of illustrate this, let me game out a situation here. You know, this segment of Conduit News Radio is brought to you by the Patriots of Act 746, and they're a great group. They're on a mission to educate Arkansans about gun rights and the constitutional carry, and specifically Act 746 here in the state of Arkansas. One story that would be of interest to them has to do with Drew Tanner, who was harassed by a Arkansas state trooper. They got the video of it. You know, he was open carrying within his rights of the law, but basically an off-duty police officer approached him and gave him a hard time about it, and then came back later, like a week or so later, followed him back to the same Walmart and arrested him. He was in uniform at that point, and so there's litigation, there's a lawsuit filed, and you're saying, I guess the question is now that particular case, which I understand is actually they are pursuing a federal case on that, but if we were to game that situation out again, you're not going to have an avenue in state court, are you? No
avenue whatsoever against any of the King's men, and the King's men are wide. That's every state university, every state hospital, the Arkansas State Police, the Department of Human Services, and all of its minions. I mean, think about the divisions. I mean, Division of Children and Family Service alone has 2,200 employees. And they're out knocking on doors all day long saying, you have to let me in, and I don't need a warrant.
Mm-hmm.
So this is, it reaches everybody in Arkansas.
Wow.
There have been, for years, egregious violations of people's civil rights, but mostly the oppression was against the poor and unsophisticated. To go back to the Division of Children and Family Services, they take the hotline calls for child maltreatment and they investigate it. And the abuse that has been running rampant in that particular organization is almost exclusively against poor and unsophisticated people. There are lawyers that work within the juvenile system that is closed with sealed records. So everything that happens, if you're accused of child maltreatment by an anonymous call, you have lost your rights in this state. Because they're gonna send somebody out with a couple of months of, probably doesn't have a child, probably some young kid out of college, a couple of months of experience, well, really no experience, and they're going to demand to come in your home and look it over and decide if you're a fit parent or not. And that doesn't happen in West Little Rock. They don't go into gated communities with $500,000 houses and snoop around. The calls are usually, a big part of them are retribution. Spouses,
a lot of spouses they call. So, like, how this is like? So, how long is it going to take before some of these DCFS workers realize that now they can't even be sued? I mean, now they have sovereign immunity.
Oh, they know it already. It's already happening. Even when they could be sued, the boldness would blow your mind. I'm heading to Fort Smith this morning for a case. It's just unbelievable. That would take a week to lay that one out. But the implications, I don't think we know yet what the implications are going to be. The cynical part of me believes that the governor and the Supreme Court and members of the legislature are all in cahoots on this, because in one fell swoop, when the Anderson ruling came down, they created a tyrant in Asa Hutchinson. There's nothing that he can do and be held accountable for now. And when I say he, that's he and all of his state agencies. There's no review by the Supreme Court of any of the actions. There is no avenue for us as citizens to have access to records and public records that we should have access to, and before Andrews, by law, had access to. So there's going to be a window of opportunity before this thing reverts back to its natural state, however that happens. But the reason I say some of the legislators, I think, are in on it too. Ace's nephew, Jeremy Hutchinson, has been the chair of the Senate Judiciary Committee for a few years, his law firm has already drafted another constitutional amendment to add the words to the end of, shall never be made a defendant in her courts unless waived by the legislature, or something to that effect. So immediately now, you've got the governor made a tyrant by the Supreme Court, and the governor's nephew, chair of the Senate Judiciary, his firm already has another constitutional amendment in the wings to fix it. They don't act that fast. They just don't. I watched Jeremy Hutchinson flounder around for several years to try to figure out how to create an adequate system of lawyers to represent indigent parents in those DCFS cases. Years couldn't get anything done, and now in just a matter of days, he's got a constitutional amendment ready to go on this issue, and I just don't believe that everybody didn't know about it.
Wow. So you're saying, Wow. Here, somebody on Facebook just wrote, "Here comes nephew number 2 to the rescue." That's how we refer to Jeremy Hutchinson on the program, as nephew number 2.
Sure. It makes them all look good. You know, the Supreme Court looks bad in a way, but then in some people's minds, they think, well, they're just holding the people accountable for that constitutional amendment that they shouldn't have done. But you got to look back. You know, that's 1874. You know, and the reason that language was put in there was in the Reconstruction age, and because we have a corrupt legislature. You know, one of those two things we still have today in the corrupt legislature, but we're not in the.
I won't trust just knee-jerk reaction any constitutional amendment that comes from the establishment part of the legislature, because they've misled us with false, deceiving ballot titles so many times. And so you say, well, here comes Jeremy Hutchinson with a fix to this. I'm like, is it really going to fix it? I don't think so.
No, that's not really going to fix it. This is going to be one of those oops, you know, where the Supreme Court on so many occasions has said, well, what we really meant was, you know, after the fact. And they can do that. But the problem is there's a window right now of opportunity for wrongdoing. Something despicable is happening right now, and we're not ever going to find out what it is until it's too late. Because we've lost the power of review. We've lost the power of extreme remedies of writ. We've lost the ability to make people accountable in our state courts, where there is no remedy in federal courts for many of these violations. You know, you're extremely limited in federal court what you can sue under because of the 11th Amendment sovereign immunity, state to federal.
Yeah.
So there's a window of opportunity right now for people to actually do about anything they wanted to do if they were set up and ready to do it. And the way this thing's come down, it makes me believe that they were. You know, bam, we've got something that just said since 1996. We've got more than 20 years of precedent with legislative waivers of sovereign immunity that are recognized by the federal government in almost every other state. There's 2 or 3 other states that have a state constitution. Alabama's one of them that says you can't sue in the state. But they have way better remedies than just a state claims commission. You know, that's our attorney general's answer to this whole thing is, well, you know, there is a remedy for every wrong, or there is a right to redress. You just have to do it with the state claims commission. Well, you know what? That's not due process. That's not adequate. You know, they don't even have to be lawyers. They're presiding over your rights, and they're going to decide what's fair.
Yeah.
This country was founded on the principle of a jury of your peers. Okay, and this decision is the left cross. Okay, and the straight punch right to the face of the private lawyer is SJRA. So when the people pass that under the auspices of the government protecting them from these nasty trial lawyers, they're not going to be able to find representation anywhere.
You think we can defeat it though? I mean, you think
SJRA?
Yeah, you think? I mean, I know it's going to be an information war, so to speak, here in the state of Arkansas with ads and stuff like that. But I mean, you think folks are going to go for that if they really know what's in the so-called tort reform amendment?
Well, I think it's possible now because of this ruling in Andrews. If people can understand what this attorney general just did, okay. Basically, this attorney general took every right that was statutorily created by this legislature, put it in a bonfire, and set it on fire.
You mean the Supreme Court? You said attorney general. Did you mean the attorney general, or did you mean the Supreme Court?
It was her brief. Somebody told her to do it. This Leslie Rutledge was not smart enough to come up with this on her own. Leslie Rutledge is the one that wrote the brief. The attorney general's office first has a duty to defend statutes. Okay, her duty is to defend the statutes of the state of Arkansas. What she did was exactly the opposite. She came in and said these statutes are all unconstitutional. Okay, that did not originate in the mind of Leslie Rutledge. And that's why I say there were a lot of people in on it. First, I look at who benefited immediately. Well, the tyrant. And so Hutchinson benefited because now it's a wide open season for anything he wants to do with all of his king's men, with no review, without impunity, and no remedy for the people. Okay, so. You know, that I think if people understand how dastardly this sovereign immunity issue is, because the Supreme Court can't just go out and reach out and sua sponte create that. Okay, the case at least has to be in front of them.
Right,
But
right.
this
The
issue-
arguments have
this-
got to be there. I understand.
Right, and the brief came. Marina Jackson actually wrote it, but Leslie Rutledge, her name is on it. She's the attorney. She's the one that said Article 2, Section 20 of the Constitution prohibits any legislative waiver. So that, of course, it was the Attorney General that had the brief on.
Okay.
So,
Joe, we are out of time, but we want to do this again soon. I appreciate you really laying bare what is a potential, well thought out conspiracy, honestly, to give the king sovereign immunity and really kind of dive it into the inside baseball. That's what I love. I appreciate it, and I want to talk to you again soon about all of this.
I'd love to do it. Just let me know when.
All righty, Joe Churchwell, everybody, a lawyer, Joe Churchwell. We've got to go to break, folks. Don't go anywhere. Back in just a moment.